Hey everybody, let's see, it's time to look at chapters 6, 7, and 8, I think. Yeah, 6, 7, and 8. Chapter 6 talks about safe evaluations and promotions. The best advice I can ever give anybody is to treat evaluations and promotions just like you would a hiring, right? A new hire. Because if you're doing all of the things legally and by the book that you do for hiring, and if you look at it that way, then you shouldn't make too many mistakes because promotions can be evaluated in just the same way as a new hire. Um, one thing, I'm on page 105. One thing it talks about here is if you do not publish a promise of performance evaluations, you do not have a contractual obligation. So there's no rule or law that says we have to do performance evaluations. I mean, it behooves you to do so because that's a really good motivating tool. It helps us make really good hiring, or excuse me, promotional decisions, pay raises, and all that kind of stuff. But it does note here, on the other hand, if you do not have an officially sanctioned and written procedure, your appraisal and promotion systems are open to challenges because they'll probably be subjectively administered. Okay. And the courts do look at that. They say, well, what's your process? How are you rating everybody? How are you deciding these things? And you go, well, I don't know. Then they're not going to look at that very favorably. So what can you do? It talks about 5 different areas. And basically, the same thing applies like in our hiring processes, using subjective criteria to produce a disparage impact on minorities or other protected groups. We wouldn't do that in hiring, would we? Number 2, using a promotion from within policy to discriminate against minorities or other protected groups. We wouldn't or shouldn't do that in hiring either. Number 3, I'm on page 106. Misusing objective records to discriminate. And again, we wouldn't want to use past employment records to discriminate if we were hiring from the outside. Number 4, now building a file, that's a little bit different. This is number 4, building a file, that is writing up your documentation after the fact. You can't make it up. I think last year they did something. I'm going to write that down. You can't do that. You can't do it retroactively. And then number 5, using a performance appraisal to retaliate for some perceived harm, such as filing an EEOC complaint. Retaliation is frowned upon. Now, the book then goes through each one of these 5 areas. Using subjective criteria, that's pretty easy to understand. So if you've had the HR class, or if you had my HR class with me or whatever, you know that I'm always saying, okay, how are you deciding that? It's like a rubric for grading your homework. You wouldn't be very happy if I just said, well, I just think I'm going to give you 10 out of 20 points. And you say, well, why? Well, because. Well, why because, right? And that's why we have a rubric, so you understand where your points are coming from. You should do the same thing. Your criteria should be objective in using a scale. Now, there's no law, again, that tells us, like it says here, we can say good, satisfactory, poor, unsatisfactory. We can use things like that, but it becomes much more, I don't want to say legal, much more legally defensive if you're using some sort of criteria that's much harder, right? Like 1 through 5, and explain what those are, and then adding up all the points so you have an average score. Promotion from within. The one thing to keep in mind is they do mention tracking on page 107. That's job tracking, by the way. That's not like tracking someone, like where are they? It's not the same thing. Job tracking is like getting you into a track. They give a good example here, like the janitorial or secretarial, right? So generally a woman would be considered the secretarial job and a man would be the janitorial. So then we get them in a track, right? That kind of track. And then when they want to try for other jobs, they're like, no, but we've got another, secretarial position in this other department, right? That prevents them getting into higher levels. Now we have a problem. And they talk about the Texas case. Misusing objective records. And again, it's being selective in how you use them, right? You can use objective records and they don't become a problem until I'll give you a good example. Have you ever worked with somebody who never seems to get into any trouble? Like the person who misses a lot of work, but they never seem to get written up, or they don't really get into any trouble. But then there's that one person, or you or whatever, like you miss 3 times and all of a sudden you're written up, you're getting a verbal. right? Oh, no, it's time for your written. You know, you've been gone too many times. And you go, well, wait a minute, Joe Schmo over here, they're gone all the time. What's going on? That's subjective use of the records, right? Now, this becomes a much bigger deal. And what they're talking about, like on page 108, if you're trying to do this with minority groups or anybody in a protected class, let's just say a protected class, right? That's going to be a big problem. Retroactive documentation, again, they're talking about building a file. And that's why I tell you, you should be watching and going through your personnel file. Wisconsin is a show me state, right? We're doing that exercise. You guys are out there looking around. I said pick the state with your name or whatever it was to see if they're an open records, not open records, or not public open records, if they have open records for personnel files. Very different, right? You should know what's in your personnel file, right? Because you have the right to correct things or say that there's something in there you object to. Retaliation, obviously retaliation, you can read that, we know that. Now page 109, what you can do, and here that's category, utilizing legally defensible performance appraisal systems. Then they have like the 4 standards here. You know, the criticism is not extreme and outrageous. The criticism is not intentionally reckless. The criticism is not intended to cause emotional distress. And the distress that criticized employee feels is not severe. So you're not saying, listen here, dummy, right? And there's people that talk like that. You may not have had a boss yet, but if you're around long enough, you'll bump into somebody that talks like that. You should not come out of your performance appraisal crying, right? And it shouldn't be a surprise. If you're a good boss, performance appraisal should be a daily, weekly, monthly, ongoing process. The appraisal part itself at that yearly or whatever it is, companies are lucky if they get through there once a year. My husband was there at his company for 28 years. I don't know if he ever got one. Half the time he never had a job description, which is another problem in this book. But anyway, that we can talk about in this book. But anyway, so if they get around to their yearly, it just shouldn't be a surprise. You should be coming in. This should be a summary of everything that you know that's been going on for the year. There shouldn't be any surprises. You say, well, you know, you're kind of borderline here staying with this company. And you're like, what? That shouldn't be it. Let's see. Just be really careful. I mean, you're using terminology like on page 110, unwritten and informal. Those are just 2 words that scare the pants off me. I'm not kidding you. When you lack the proper documentation in a personnel file, it's like anything else. It's he said, she said, right? And the other problem with that, without proper documentation and legal documentation and consistent, here's what happened. They talk about the halo effect and Demon's Jaw on page 110. Halo effect. So what happens is, and this is based on rate or error. We call it rate or error in HR. So the halo effect is maybe, you know, you've just done something absolutely fabulous, right? Right before you come in for your performance evaluation. And this little halo is still there, right? You rescued a puppy out of a burning building. It's like, oh my God, they're wonderful. As opposed to you did something really bad not too long ago, and that's in their memory. And you come in and now you're wearing those horns, right? It's still a little halo. The Demon's Jaw, and that happens too. Now, there's like 7 or 8 rate or errors, and in the HR class we talk about this stuff. So I won't go over it again, but just keep in mind that people have opinions and we're humans, and what is happening before, after, and during a performance appraisal can affect that. Let's see. As far as on page 112, there's no one style of appraisal that, like, there's no legal guideline for any of that. I just always, you know, tell one of my head clients and said to them, just make sure you're consistent. Whatever style you pick, use it for everybody. There you go. And that helps. Now, one thing, go to page 114. And this again is about the personnel file. The organization has to keep other employee personnel files also, but they can be used against you even if you were put together, even if they were put together by other supervisors several years prior to the present circumstances. Okay, so keep that in mind. Federal courts have found that supervisors can deliberately place an inaccurate discriminatory evaluation in the employee's file with the intent to harm the employee. That record then follows the employee and adversely affects his or her future opportunities or conditions of employment or compensation. It's not here. They're telling us, therefore, you should give employees the opportunity to view their evaluation files, to be able to go in there and refute them, right? So that's another thing why I wanted us to go out and look at how many states are show me states that they will actually, you can do this without getting a court order, for example. And I'll give you one example. A friend of mine years ago was working in a warehouse. She was managing or supervising in a warehouse facility, and she got called up for sexual harassment. She's like, what? I'm the only woman that works here, right? Well, it turned out it was a young man that filed the case against her. And that's a big deal. HR was right on it. It was a big company. And as it turned out, she's from the South. She uses words like, and maybe I've told you this before. If I have, you can tune me out. Honey, baby, sugar, sweetie. She calls everybody that. She calls me that. She calls everybody that, right? And he misunderstood it. He really did. And so as it turned out, they sat down, had a conversation, and then he understood. She apologized and said, I never thought anything about anyone misunderstanding that. So everybody was on the same page. But what she did make sure, and when she was telling me about this at the time, I said, well, you need to make sure that in your personnel file, that this is modified, that this is explained and written up and modified, because I said having a sexual harassment charge brought against you, and that's all it says in there, is a pretty darn bad thing, because it follows you around. That's pretty much it. The case book, you can read the cases on your own, and the ones that we'll be using in our work. Chapter 7, safe management, the right to privacy and defamation. And you guys who did some short answer, and you're looking at the privacy policies of your companies and things like that. So we don't need to spend a lot of time here. And a lot of this is procedural. Like you can see on 127, First Amendment, 4th, 5th, 9th, 14th Amendment type stuff. So you can read that. You don't need me to read it to you. Access laws on page 129. Without right of access laws, employers may deny employees the right to inspect their own personnel records. So that's what you guys are investigating now. Page 130, like things like mandatory medical screenings. You may not think of that as a privacy issue, but boy, it's a huge issue. Like people's biggest worry is that your medical records will get out, and pretty soon you can't get insurance, right? And that's why there's hesitation to have universal access to medical records. But any kind of medical screenings, mandatory medical screenings, most of these are not legal. Don't ever have, if an employer ever asks you to do that, you can deny that. Now, it has to be a bona fide occupational qualification, like for a pilot or truck drivers or whatever. But if you're going to be working at the 7-Eleven, there's no real reason they should be doing a medical test for you. Now, drug testing, whole different thing. And we all pretty much know how that works. But again, consistent and across the board for everybody. Now, when we get on page 131, they talk about written and other types of screening tests. This is these personality tests. Now we have a big problem. And this settlement was $1.3 million for 2,500 job seekers, because the company, this retail chain, was subjecting them to the Rogers Condensed CPI MMPI. The MMPI is Minnesota Multi-Personality Index, I think. Old test, it's ridiculous, yeah. These are psych screenings, these personality tests. Now, a lot of you have agreed when we talk about testing. We shouldn't be doing these to promote, hire, fire, anything like that. They're fun to do, and they can be enlightening and all of that. So I'm not opposed to that. But I am opposed to them being used for any kind of legal purpose or legal decision making. Oh my gosh, don't ever take a polygraph. That's ridiculous. They've been proven inaccurate over and over and over. That's pretty much, this does also apply to when we talk about people calling and asking on our job reference, like so-and-so has you down that they worked there from, June of, 82 till whatever, 82, some of you weren't born. Shows how old I am. Anyway, that's why we kind of hear employers that say, oh, name, rank, and serial number. I'm not telling them anything. I'll get sued. Well, if you've had an HR class, you know that that's not the truth, right? But we do have to be selective that we're not doing anything that would cause disparaged treatment, meaning keeping them from being able to get a job. We can say things that are true, that sort of thing. Then it goes Oh, it just talks about the same stuff. Now, I have a good example about voicemail on page 140, email, voicemail, and this other issue of privacy. And that's why I got you guys looking at your companies, seeing if they have policies on that, written policies on that, not informal and undocumented. You guys, if you remember or know, my brother became a quadriplegic last fall, and he's worked his way up through the spinal cord injury unit in the VA in Milwaukee to the point where he can use a wheelchair now. And we actually just brought him home a week ago yesterday. And I couldn't figure out why there was this big delay at the end of February coming into March. I couldn't get a hold of people. I said, what is going on? About 2 weeks went by and I was starting to freak out because I wasn't able to drive down there. Finally, on the phone, I tell my brother, you need to get in your wheelchair. Next time you're in your wheelchair, I said, you drive down the hallway. I said, where your social worker is. I said, on the same hall is the other social worker. And see what's going on because I can't get a hold of this guy, his social worker. So he did that. He gets back to me and says, you aren't going to believe this. Our social worker's been gone for like 2 weeks. I said, well, no wonder, but what's that got to do with anything? You know, they're supposed to be, he was in the process of working on your discharge. They couldn't get into his voicemail. It's all passcode or whatever you call it protected, right? And these are federal records. Veterans Administration, social worker, that's like, you know, the trifecta of, you know, legal firewalls for anybody to look. So they literally couldn't get into his voicemail. I'd left like 100 voice messages going, what's going on here? So the other social worker was just scrambling because she says, we can't get at his files to figure out where he's at because I'm the one that coordinates everything for him. So privacy is taken very seriously in a lot of instances. So they give us the sample policy you can take a look at. And then, of course, the cases. And then Chapter 8, Safe Management of Family Medical Leave. Oh my gosh, we'd be here for a week if we were going to talk about FMLA. And I'd have to go back and take some classes to get caught up with FMLA. It's very confusing. There's state FMLA, federal FMLA. The most we're going to do here is that I want you just to read this so you have a good understanding of it. You know, and most of us know that FMLA entitles you to, you know, a reasonable amount of unpaid leave for, you know, different things going on with your family. Okay. And whom the act protects, I want you to read this more from the perspective of you as the employee, because you should know your rights. You should know that you do have the right to use FMLA, right? You're not going to be administering this or digging into this at all unless you're in HR, pretty much. That's pretty much it. If you have a big enough company that qualifies, you know, like over 50 employees and all of that good stuff, you're going to have somebody who does this. Legal department, HR, whatever. But on page 173, it's kind of interesting to look at how we can, the reporting methods, calendar year, fixed year, measuring forward, or rolling back. The first three, people figured this out pretty quick. I know people that can hardly tie their shoes some days, but I'll tell you, they figure this thing out, and this is how to, you know, play the system. It's called stacking, and they talk about it here, where if you do it just right, you could end up with 24 consecutive weeks being off. So we recommend that you use the rolling back method. So that's just kind of an FYI. Oh, and that's about it. It's like 3 pages, 4 pages, whatever, 5 pages. So that takes us through chapter 6, 7, and 8, and then we'll be on to the next one. All right, everybody. See you next time.